Dr. Marija Pijaca, who will also deal with maritime labor law, but with an eye on the national legislation in the Republic of Croatia. So the application and implementation of international rules and national laws in Croatia. So Marija, please, the floor is yours.
Good morning, dear colleagues, dear friends. Good morning. First of all, I would like to greet you, of course, and I have to say that it's really a pleasure, as always, to be here in Dubrovnik and be part of the International Maritime and Transport Law course here in Dubrovnik University Center. So, as you know, this morning the lectures are dedicated to maritime labor law. So I will continue with the same topic with a presentation titled Maritime Labor Law in Croatia, and we will see an international as well as national legal regulations in this field. First of all, I would like to point out that the aim of this presentation is to show you, to present international and, as I said, and national legal sources related to the labor rights of Croatian seafarers. First of all, I will present international legal sources to which Republic of Croatia has committed. The most important source is, of course, Maritime Labor Convention from 2006, and up to that, I will present the full series of national legal sources related to Croatian seafarers. My focus will be, of course, Croatian Maritime Code, but I will also represent a huge list of other laws and regulations from this field. Plus, we cannot forget that the legal framework in this subject matter is also part of the same legal regime, is also an autonomous legal sources. I mean, collective agreements, and I will present some provisions from our most important collective agreements when we talk about maritime labor law for Croatian seafarers. So, in this presentation, after a really short introduction, I will explain some specifics about seafarer status, and then we will see international legal sources related to maritime labor rights of seafarers, and after that, national legal sources related to the same topic. As I said, Croatian Maritime Code and its provision will be my focus, and I will show you and some other laws and regulations in this field, and then I will present also some provisions from our two collective agreements, and at the end I will make some summary from all these topics. So first of all, I would like to represent some specifics about seafarers' status. Because they are a special category of workers. So seafarer is the person who signed an employment agreement. It means contract to work on a ship, or maybe on a floating object, or maybe on some offshore facility, or maybe on yacht, or maybe on some other facility or vessel for special purposes. In Croatia, we have approximately 20,000 seafarers, and I have to say that a huge number of our Croatian seafarers, around 50,000 of them, take part in international navigation, and the rest of them, it means around 5,000 of them, take part in national navigation. I have to say also that part of seafarers have not officially been registered in the Republic of Croatia, and part of registered number of seafarers is not active. It means that they probably finished maritime high school, or maybe they finished an faculty of maritime studies, but actually they are not active as seafarers. So when we talk about seafarers employment agreement, I can say that the seafarers employment agreement is not one of the most specific ones today, because really they are seafarers a special category of workers, because their place of work is also and their place of living, and that's the most specific think about it. So their working conditions are really different in so many ways. That, for example, working and living conditions of workers in another economic activities which are, for example, performed on the land. And that's the reason why legal regulation of seafarers, the maritime, of course, labor law, it is really important. Also, on the other side, seafarers are probably the most important component of the maritime value chain. They are important as a ship itself. So seafarers' role in maritime industry is a really crucial one. Also, our Croatian seafarers are probably over this last 30 or maybe 40 years are the most competitive seafarers in maritime industry at the moment. They are well known as good workers, good seafarers. So our Croatian seafarers, they put our country in a position of long-term maritime crude supplier. If we take a look at this slide, for example, we can see detailed overview on which type of vessel our Croatian seafarers are usually sailing. These are actually results of research of company Zorovic, who is a crude management company from Pijaca, from Croatia. And the biggest number of our Croatian seafarers are actually on tankers and also on offshore facilities. Then a huge number of them are also seafarers on passenger ships and on LNG vessels and on bulk carriers. And there are also some of them on, for example, containers or general cargo vessels. Also seafarers, I have to say, they leave their families, they leave some kind of normal, traditional life to stick with the ship on seas, and they are exposed to a lot of dangers, such as, for example, this one. So because of all of this, I think it's really necessary to take into account their labor rights and to legally do everything what is possible, everything what we have to do to make their work as well as their life on board as good as it possible. So definitely this is not an ordinary labor relationship, and that is recognized. That is recognized on international level and also at the national level. So when we talk about international legal services, as we know, topics is really huge, but maritime sector definitely represents a special challenge for international labor law. So on the international level, I have to say, and as you could see from the previous presentation, I think that a lot has been done in terms of better working rights for seafarers and provisions in the field of seafarers labor law. And for that provisions, of course, the work of international labor organization is really the most important one. So seafarers have always been really special concern to the International Labor Organization. As you know, International Labor Organization has more than 100 years of experience in the maritime sector, and of course, our country, the Republic of Croatia, is one of the members of such organization. And one of the first legal instruments that International Labor Organization adopted was this one, National Seamen's Code Recommendation. And this legal instrument was adopted just a year after International Labor Organization was created. So it is proved how much they do for seafarers and how much they work for maritime labor law. And of course, in February 2006, at its 94th session, International Labor Organization adopted the most important instrument when it comes to maritime labor rights. Of course, it is Maritime Labor Convention. All member states, ship owners, seafarers voted for this convention. Of course, in our country was ratified same convention in 2010. Maritime Labour Convention has been amended a few times, and usually in literature we can see that same one has been described as historical, as a way forward using international labor standards to establish decent work and also fair competition and to help to achieve fair globalization. This convention has actually two primarily purposes, what we can see for its provisions. First one is to ensuring decent work. It means to bring the system of protection contained in existing labor standards closer to the workers concerned, in the form consistent with a rapidly developing globalized sector. And the second purpose of same convention is to improve the applicability of the system so that the ship owners and the governments interested in providing decent conditions of work do not have to bear an unequal burden in ensuring protection. So this convention came in the moment, in a really important moment, because same convention was actually a response to the globalization, and in that moment, so many international labor organization instruments were outdated. So also there were some changes in industry, such as mixed nationality groups, open registers as well. So international labor organization respond with the same convention like it did. So the International Labour Convention revises also so many other conventions. You can see huge list of other conventions which was need to change. Some of these conventions are really old ones, and there are some new conventions, such as, for example, minimum age convention, unemployment indemnity convention, placing of senior convention, medical examination of young person convention, seniors articles of agreement convention, repatriation of senior convention, and so on, or such as, for example, convention which is dedicated to seafarers, welfare convention, health protection and medical care convention, social security convention, repatriation of seafarers convention, and so on and so on. Also, this convention is described as a fourth pillar for international maritime law, together with some other conventions. First of all, the SOLAS Convention for Safety of Life at Sea, as well as with the SPWC Convention or International Convention on Standards of Trading, Certification, and Watchkeeping for seafarers. And also one important pillar is also Environmental Convention, International Convention for Prevention of Pollution from ships. So all these conventions are part of international regulatory regime for quality shipping. So these conventions support quality shipping, and they help to eliminate substandard shipping. So there is of course question, what are seafarers' rights under the same convention? So the Maritime Labour Convention has actually five titles, as you know, which taken together set out all members under the convention. So first title is dedicated to minimum requirements for seafarers to work on ships. You can find provisions from Article 24 to 41. Second one is dedicated to conditions of employment. And next one to accommodation, recreation of facility, food and catering. Title 4 is dedicated to health protection, medical care, welfare and social security protection, and Title 5 to compliance and enforcement. So each title contains groups of provisions related to particular rights or principles or maybe enforcement measures, which we can find in Title 5. And the same convention has three underlying purposes. First one is to lay down its provisions in its articles and regulations a firm set of rights and principles. And then the second principle is also to allow a considerable degree of flexibility in the way members implement those rights and principles, which is also an important part of purpose of this convention. And the last purpose is to ensure, especially through Title 5, that the rights and principles are properly complied with and enforced. Also, there is a question, how are these seafarers' rights to be provided? Actually, the answer is pretty simple. So the seafarers' rights, which are set out in this convention, are implemented by flag state and its ship owners in accordance with the requirements of the Maritime Labor Convention, unless specified otherwise in convention. So implementation of seafarers' rights may be achieved and through national rules and regulations, through applicable collective agreement and other measures, or maybe more in practice as well. So first, Title 8 is dedicated to minimum requirements of seafarers to work on ship, and in this part we can find provisions about minimum medical certificate, training and qualification, and some other provisions. Title 2 is dedicated to conditions of employment, and you can see provisions titled such as seafarers' employment, agreements, wages, hours of work, repatriation, medical levels, and so on and so on. For example, in this Title 1, these provisions prescribes the minimum age of 16 for admission to work in maritime affairs. And also there is a provision which says for example, that seafarers under 18 years, they are not able to work, for example, during the night. There is also a provision which says that every seafarer must have a health certificate before being employed on board, which is proof of his mental health and also his physical health. In Title 2, for example, this chapter prescribes the longest period in which the employer is obliged to pay the worker a salary for work performed, as well as the longest duration daily and weekly working hours, rest time, right to repatriation, use vacation, and so on and so on. In Title 3, we can find provisions dedicated to accommodation, recreational facilities, food and catering, and this next title is dedicated to health protection, medical care, welfare, and social security, where we can find provisions such as this one, the title medical care on board and ashore, ship owner liability, health, safety protection, and accident prevention, access to shore-based facilities, securities, and in Title 5, which is dedicated to compliance and enforcement, there are provisions dedicated to flag state responsibilities, recognized organization, inspection and enforcement, on-board compliance procedure, port state responsibilities, onshore compliance procedure, and also labor supplying responsibilities. So many provisions, so many provisions to analyze and to read. So, for example, in this Title 5, for example, in this part, we can find provisions about port state responsibilities under Maritime Labor Convention. According to State 1, port state control inspection under Maritime Labor Convention is to be carried out by authorized officers. Inspection is really important part of this whole story. So this means that a person must be authorized by a competent authority in the port state to carry out these inspections, and should carry official identification that can be shown in ships, masters, and to seafarers. Also, there is a question how seafarers know about all these rights. So, according to Maritime Labor Convention, seafarers are entitled to read and also to sign and have a copy of their seafarers' employment agreement, setting out the conditions for their employment and the name of ship owner that is responsible for conditions on board. So also according to MLC, a copy of MLC must be on board ship and be also available for seafarers to read. I will just briefly mention some other provisions from this legal source. For example, in Article 2 of MLC, this one helps to ensure that seafarers are also provided for the fundamental rights related to freedom of association, elimination of forced labor, of child labor, discrimination as well. And for example, Article 4 of MLC states that all seafarers are entitled to a safe and secure workplace in compliance with safety standards, fair terms of employment, decent working and living conditions on board, health protection, medical care, welfare measures, and other forms of social protection. So, in addition to MLC, as of course an important source of legal regulation for working status seafarers in the Republic of Croatia, of course, and national legal sources related to the labor rights of seafarers also appear. So, Croatian Maritime Code, of course, is our most important legal source in this field, but there are also some other laws and regulation plans. Of course, there are two collective agreements in force in our country, which prescribes the status of seafarers. First one is the National Collective Agreement for Croatian seafarers on board ship in international shipping trade. This collective agreement is for the year 2021 and also 2022. And another one is National Collective Agreement for Croatian seafarers on passenger ships and ferries. This legal source is a little bit older, it's actually from 1998. But before I show you some provisions from our Maritime Code, and also from our national collective agreements, I will just briefly show you the list of other laws and regulations which are also important for the field of maritime labor law. So first one is the regulation of maritime booklets and authorization for boarding and procedures and means of registration and termination of compulsory pension and health insurance. Briefly, this regulation prescribes conditions for the acquisition of maritime booklets and also authorization for boarding. And it is also prescribes conditions for seafarers' documents, information contained in maritime booklet, competence for date, verification for insurance of maritime booklet, and registration procedure for compulsory pension and health insurance. Next one is regulation on titles and certification of competency of seafarers. As you can see, there are 10 parts of this regulation, and there are also some important provisions, such as, for example, basic competencies for seafarers or additional competencies, then procedure of delivery of certification of competency, because these certificates are also important part of the rights, labor rights. Then regulation to amend and supplement regulation on titles and certification of competency of seafarers. In this one, we can find some new definitions and also some conditions for certification and some other minor amendments. And also, I have to mention a degree to supplement the degree on categories of navigation of seaborne ships, where we can find new section which classifies different sea areas and determining navigation of ships and other required reasons from the course. Then there is also a degree on mediation in recruitment of seafarers. For example, in this one, we can find also rights and obligations of mediator in the procedure of recruitment of seafarers and the system of mediator supervision. I have to mention also in regulation to amend and supplement regulations and titles and certification of competence on merchant marine ships, and in this regulation, inter alia, we can find provisions relating to the competency to work on ships transporting chemical substances, and we can also find provisions about fire protection, training program, and equipment maintenance. There are also some other regulation. This one is also important. I have to mention that one, and that is regulation on the minimum number of crew members that must be on board of merchant marine ships for security of navigation. As you know, minimum number of crew members is also important part of safety on board, not just part of the maritime. Then regulations to amend and supplement the regulations on tasks and guards of crew members on the merchant marine ships. In this one, this one presents actually an annex or format for a table of shipboard working arrangement and selected text from International Labour Organization Convention, which is dedicated to seafarers' hours of work and the manning of ships convention. So many different sources. For example, this is actually the last one. So there is also regulation on ships, booklets, and authorization to embark, as well as regulation on titles and certificates of competence of seafarers on merchant marine ships. So there are so many legal sources in this field, because in the Republic of Croatia there is not just one legal act which regulates labor law of seafarers. So these provisions are contained, these provisions are actually in several regulations. But as I said, the most important source of course is maritime code, our maritime code. So my focus will be on that legal source. But here I also want to point out, when we talk about maritime, our maritime code, that when it comes to labor rights, operation seafarers, it took time for operation maritime legislation to recognize these specific seafaring and to recognize problems of seafarers. So it takes time. So it was not until 2007 that the passing of the Act of Amendments to Maritime Code finally established, for example, health and also pension system for our seafarers, and a system of payment for mandatory and insurance. So according to our maritime code, all seafarers on board ship in international navigation, regardless of the ship's nationality, are equal, finally are equal to the rights and obligation with respect to pension and also health insurance. So the obligation of Croatian employers to register the seafarers that are not connected to Croatian pension and health insurance institutes remains. Also, according to Maritime Code, the seafarer in international navigation shall be payer of the contributions for mandatory insurance according to monthly basis for calculating the contributions, which is stipulated and which is published by Croatian Minister of Sea Transport and also Infrastructure. So the amount, I have to say, the monthly basis for calculating of the contribution is determined according to the salary that the seafarer would receive for some or maybe similar jobs on board a ship in national navigation. Also, there is one interesting provision from Maritime Code, and that is article number 128. Same article actually provides we can find in this one provisions refers to cases of, let's just call it, inability to realize 183 days of navigation for the exception from the tax obligation of seafarers based on work on board the ship in international navigation. So Maritime Code actually stipulates that some days and some situation shall be included for the purpose of achieving this necessary 183 days of navigation in the year in which income tax obligation is established. For example, we can include all these situations for the purpose of achieving the necessary 183 days of navigation. It means there are days of navigation, days of traveling from the place of residence to the place of embarkation, then days necessary for return trip back home. Also, days of treatment due to illness or maybe injury occurring while traveling to the place of embarkation or on board or during the return back home. Also, days of treatment due to illness or injury occurring after this embarkation or before the embarkation, which would prevent the obtaining of certificate of medical fitness for navigation, as well as days spent in training aboard or maybe in the country, as well as days until the expiration of employment agreement that can be realized because the ship owner left the crew member or maybe because termination of employment contract due to business-related reasons. So all these days we can have in mind. So all these days are included for the purpose of achieving this necessary 180 days of navigation in the year in which income tax obligation is established. But there is also one interesting provision in Maritime Code, which stipulates that the Minister of Sea Transport and Infrastructure may participate in covering the cost of salary and also the contributions for mandatory pension and health insurance of seafarers during their traineeship. Our young seafarers are really happy with this provision because it's huge help for them to be able to go on ships. So the conditions for determining the rights to coverage of are laid down actually by the minister in special regulation and special rules. I will also mention one other provision for Maritime Code, and that is this one here, which is dedicated to seafarers' pension. So the regulation of seafarers' pension is within the scope also of Maritime Code. So according to Maritime Code, for example, the seafarers are entitled to a pension at the age of 60 and after 15 years of navigation, and that provision is different than, for example, general regulation of pension, which said that employees in general realize their rights to pension after 15 years of work, and at the age of 65. So many provisions, so many provisions to add. But as I said, let's mix this up with legal sources and with collective agreements. As you know, today, labor law in the world in general, we cannot imagine without collective agreements. They are really important parts because of their economic function, political, social, and educational function. So collective agreements can be defined as a written agreement, and we talk about these collective agreements for maritime labor sector. They are always concluded between seafarers union and employer. So collective agreements include provisions on employment condition, payment methods, working hours, and other, we can find some other rights and obligations of the contracting parties in that. As I said, there are two collective agreements in force in our country, and first one is dedicated to our Croatian seafarers on board the ships in international shipping trade. That one is from 2021. And the second one is dedicated to Croatian seafarers and passenger ships and also on ferries. So this first collective agreement, international collective agreement for our seafarers on board ship in national shipping trade, this one is concluded between Marija and Marija is Croatian Ship Owners Association. And another party is Seafarers Union of Croatia. Our Seafarers Union is member of International Federation of Transport Workers. And Marija, I have to say that members of this association are our Croatian ship owners and other ships such as Carolina, such as Barcelona, and so on. This agreement, this national agreement, is applicable to all Croatian seekers, which with either permanent or maybe temporary residence in Croatia, serving on board ship in international trade, and also registered either in Croatia or maybe in other register of ships. Also, this collective agreement has been brought in competence with provisions of course, Maritime Labor Convention. Collectively, this one is completed for 2 years, as you could notice, for the year 2021 2022, and if none of the contracting parties cancel after its expiration, it will be extended until termination or conclusion of maybe new collective agreement, we will see. So in this one, we can find provisions dedicated to hours of duty. According to this collective agreement, the normal hours of duty for all seafarers shall be 8 hours per day, which makes a total of 40 hours per week. Or monthly, it is 173 hours on the average. Then there is also provision of overtime, that is important part as well. So any hours of duty performed in excess of 8 hours shall be paid at the rate of 1.25 of the basic hourly rate according to the rank on board and to weekday hourly duty. Also, there is a provision which says that in the case of emergency, so there shall be no overtime pay for any additional hours work during an emergency affecting the immediate safety of the ship, for passengers or maybe crew, or for safety drills or work required to give assistance to maybe another ship or person, or fire drills or any drill provided for and by international management code for the safety operation on ships and for pollution prevention, and also provided by safety management system, international ship and port facility security, as well as in the cases of drill provided by safety of life declaration. And I think that is really correct. Then we can also find provisions of public holidays, rest period provision that is also important, which says that each seafarer shall have a minimum of 10 days rest in any 24 hours period, in 77 hours rest in any 7 days period. Of course, there is a provisions about wages, family, and other things. Annual watch keeping, for example, according to this one, watch keeping shall be organized in 3 watch bases, and there is also provision to manage levels, services in worldwide operation area or higher risk area, and in these days, we know how much is important that provision that we have war between countries. Then groups, safety and welfare in emergency situation, and also, of course, there's a provision about termination of employment. For example, according to state laws, the employment shall be terminated upon expiry of the agreed period of service, that is of course normal, upon signing off due to sickness or injury after medical examination, or maybe upon termination of the employment agreement. Either or by seeker or employer itself. Any seeker may also terminate a contract in some cases, but always with giving 1 month notice of termination, and then during, for example, voyage, maybe his child or some other member of his family has dangerous injuries, or if the ship is about to sail into a worldwide operation or maybe in high-risk area, or if the ship does not meet the standards in relation to the provisions of some international international conventions such as SOLAS, of course, International Convention on the Log Lines, or FACW Convention or Marco Convention, or if the ship has been arrested as well. And on the other side, a movement border also may terminate seafarers' employment agreement, but always also with giving month written notice to seafarer, or in situations such as, for example, this one, total loss of the ship, or maybe in the cases of seafarers' serious breach of war duties, for example, in the case of unlawful possession of drugs, alcohol. Unfortunately, we have that kind of situations in practice as well. Then, due to seafarers' inability to perform to work and duties properly, that is also a possible situation. And our next source is national collective agreement for our Croatian seafarers on passenger ships and also on ferries. As I said, this one was concluded a pretty long time ago, and it was concluded between Croatian seafarers and also Association of Croatian Seafarers. And it is also detailed like this previous one, and includes more than 100 articles. And these articles are also divided into heads, and we can also find some attachments in this one, such as, for example, the minimum number of crew members, food, salary table, and so on. So this national collective agreement regulates the labor law of seafarers who sail on ships under the Croatian flag, and which the ship owner performs regular liner services or maybe maritime transport of passengers and cargo in internal sea waters or in territorial sea of the Republic of Croatia, and also in international navigation. But I want to point out here, when we talk about this one, that for a long period there has been a need to conclude a new national collective agreement for our seafarers on passenger ships and also on ferries, because provisions which we have at the moment should be better, should put our Croatian domestic ship owner companies in better positions, because if this collective agreement which is in force actually puts domestic shipping companies at a disadvantaged position to the European competition, because at the moment, since actually 2018, all ship owners from the European Economic Area, they can apply to tenders for the awarding the concession and the conclusion of contracts in state lines for regular lines transport in internal sea waters as well as in territorial sea of the Republic of Croatia. So we have to change these provisions, that's for sure, and put our domestic shipping companies in better position because of this influence of the EU. Just really to mention one more collective agreement, but this one is for non-EU seafarers serving on board of Croatian flag vessels in international shipping trade. As you can notice from the title of this one is for non-EU seafarers. It means that it's not for residents of Croatia or European Union / European Economic Area. So that's why I didn't mention in more details this one. So at the end, I would like to say one more time that really seafarers are definitely a special category of workers, and working conditions for them definitely are different in many ways for example, working and living conditions of workers in some other economic activities which are performed on land. And that is the reason why legal regulation of seafarers we have to take serious, and it is really important part of law. So the great success definitely in this area was made with adoption of Maritime Labor Convention from 2006, which was ratified by our country in 2010. And of course, in the field of national legal sources, Republic of Croatia, there is not just one legal act which regulates these rights of seafarers and maritime labor law in general. So these provisions are contained in also in several other regulations, and of course collective agreements are really important acts, and two such collective agreements are in force at the moment with public cooperation. The first one dedicated to our ships, to our seafarers and ships in international shipping trade, and that one was concluded in 2021. And another one is for our seafarers, passenger ships, and also on ferries, which is concluded from 1998. So these legal sources are really detailed, as you can notice. But I think, and I'm sure that you can say the same thing, and that is that labor law is really a leading matter. So it needs to be contained constantly in our focus. So there is, I believe, certainly room for improvement in labor rights of seafarers. Plus, it is really important of labor law we cannot forget also in this part, safety of navigation and protection of marine environment. So the improvement of labor law is also important, and for safety and for protection of maritime environment. So thank you very much for listening.